the first thing I will observe is that, okay, John's fixed his collar now. Not you, John, but Justice John. Good morning, everyone. First of all, if I could get a head shake that y'all can hear me. Okay, so everybody can hear me. Welcome to the 10th Court of Appeals oral argument session. We are not proficient at this, but at this time I would like the clerk to call us to order. You're muted, Nita. Or to be down on your toolbar on the lower left of your screen.
Okay, got it. The 10th Court of Appeals for the Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
Thank you. At this time, I would ask you to be seated, but you already are, so we're all in good shape. So, we are sort of new at this, even though we've held several of these. We have not done a lot of oral arguments during the C-19 period, so bear with us with our lack of technical proficiency. The other judges will laugh because I'm in my office trying to manage the clock and the cameras and get everything done. So a little bit of etiquette. And I noticed both of you have your mics off, which is perfect for the time that you are not arguing. Additionally, if you turn your camera off, when you are not the one arguing, it avoids distractions. It lets you be where you can see, but not be seen. Nita, well, you'll be off in a minute. I noticed neither of you have anything in the background, although Counsel John's door is open. Maybe there won't be too much traffic there. Don't worry about it, John. Don't worry about it. That's fine. But if I'd ask you to kind of check your surroundings, try to turn your cell phones and your office phones where they're not going to interrupt us. So we only have one case on the docket today, and I'll call it in a minute. I hope that you were able to pass along to your clients the YouTube channel. This is being recorded right now as we speak. Even before I went live on the YouTube channel so your clients could join and see, or you can have other counsel join and see the arguments. Before C-19, the court had gone to a policy of tape recording the oral argument sessions. We didn't video record, we just did audio recordings. We linked those in our case management system after the fact to the argument or to the case so that other people could hear the oral argument if they wanted to. We have changed that procedure now in that when we video or broadcast on YouTube to maintain the open court's nature of our process, that broadcast is recorded on YouTube. We do not, absent the exercise of our judgment for other reasons, erase that recording at a later date. We will use that recording, both video and audio, to link to the case management system. So as long as it's out there on YouTube, it will also probably be linked in our case management system. So if there's something that comes up about the argument in the future that y'all want to refer back to, you should be able to do that as well as your clients. You will note that the timer is set for 22 minutes instead of 20. I figure there will be at least 2 minutes of wasted time during our attempts to ask questions or exchanges. And so I've added that time in to begin with. We are interested in the arguments. And by that, I mean rigid adherence to the time is not absolute. If you can always give us back time, but also if you're on a roll, I'm going to bump you some time, and I won't even say anything. I'm just going to reach over here on the timer and bump it if I feel like we need to do that. This, because it is being recorded, please note that we may also see some traffic on the channel by two universities, Sam Houston State and Blinn. Both have students or programs, courses that they conduct that sometimes use oral arguments. We used to actually travel twice a year, once to Blinn, once to Sam Houston. We will actually be holding a session on the 20th of April, specifically for our Sam Houston audience, but we won't be traveling there. We'll be conducting it like this. They may choose to go to the YouTube channel as well as anybody, any member of the public can. So before I call the docket, first colleagues, are there anything that you think I've forgotten to mention or that I should mention?
No, sir.
No.
All right. From the litigant's perspective, is there anything do you have any questions or anything before we begin?
Good morning, Your Honors. I would just say that the reason my name shows up twice is I have a backup method here in case my internet connection dies. So we'll see how this goes. That's the only reason I show up twice.
Okay.
And Justices, I am a computer dinosaur. So when you say turn my camera off, I'm not sure I know how to do that.
Then don't do it. Then don't touch it, because we don't want you to leave. So Lisa, with that, we will let John stay on the screen while you are doing your oral argument. You see the high-tech captioning process that we use here as well. So so the case on the court's docket today is Txdot versus Kathleen Galloway Poe. Docket number 10-19-00130 CV. Is the appellant ready to proceed?
Yes, Your Honor.
Is the appellee ready to proceed?
I am, Your Honor.
Then Counsel Mitchell, you are still on mute, but you may proceed when ready.
Thank you. Good morning, Mr. Kerr, and may it please the court. Txdot asked this court to reverse the trial court's denial of Txdot's plea to the jurisdiction and render judgment for Txdot because all actions complained of were discretionary, and therefore Txdot's immunity remains intact. Additionally, the record shows there was no condition or use of tangible property sufficient to waive Txdot's immunity, nor was there a premises defect or a special defect. There was no proximate cause by the placement of the circular traffic signal, the green solid ball at the intersection. And finally, the state was entitled to and did in fact follow its own manual on uniform traffic control devices. Txdot retains its sovereign immunity because all acts complained of were design related and therefore discretionary. As you're aware, the Texas Tort Claims Act in section 101.056 protects governmental entities from that type of discretionary decision. Texas courts have long held that Txdot enjoys immunity for its design decisions, including the choice of which traffic control device it uses on its roadways. Here, Txdot's decision to place the circular green ball signal was discretionary and therefore immune. In order to overcome Txdot's immunity for these discretionary decisions, Ms. Galloway must show waiver some other way. First, the condition of the intersection where the green circular ball signal was placed was not a premises defect. It's not a condition or use of tangible property. Ms. Galloway tries to circumvent the heightened standard for premises liability claims by reframing her claim as a condition or use of tangible property. That's because, of course, it's easier to demonstrate this type of thing than it is to meet the premises defect elements. The use of the circular green ball was not a condition or use of the property, nor was the sag in the road that is also complained of. But really, Ms. Galloway's complaints aren't about the circular green signal or the sag in the highway. It's more about this limited visibility that was caused by the topography in the area. But limited visibility is not a condition or use of property. For example, no Txdot employee was putting any tangible property to use at the time of the accident, nor was it in any kind of defective condition. If you look at the Sampson case that I believe both parties have cited, in which a University of Texas professor tripped over an extension cord that was extended over a sidewalk, he attempted to bring that as a condition or use of property case. And instead, the court held it's not a condition or use of property, rather it's a premises defect. Because Mr. Sampson could not demonstrate that the University of Texas had actual knowledge of that condition, he couldn't demonstrate a premises defect. Active use of tangible property must be shown to waive the state's immunity. If the property simply provides an instrumentality for a condition to occur, that's not enough to make an accident more likely and therefore waive Txdot's immunity. There was no condition or use of real property at issue here, or pardon me. So Ms. Galloway must demonstrate instead a premises defect, but she cannot do that. To show a premises defect, she would have to show that there was an unreasonably dangerous condition of which Txdot knew and she did not, or pardon me, her parents did not, and that the government failed to warn of that condition or make it safe.
Counsel, let me interrupt you. There was just a little bit of a glitch right at a critical time in me trying to understand here. You were talking about the light fixture, the head, I think they call it, and whether or not it was a condition or use. And when I think of that part of the statute, I almost always in my mind insert the word personal property, condition or use of tangible personal property. One, is that out of the case law or is that in the statute? And two, is a signal light device attached to the ground, does it become a fixture and therefore take it entirely out of the condition or use of personal property or condition or use of property?
Okay, to answer the first question, it's in the statute, the condition.
Just 1 second.
I'm sorry.
No, go ahead, John.
Nita's brought it to my attention that even though you're going to be liberal with the timing, that the timer has not started yet.
It is not.
Okay.
So I will start it and we'll mark off a couple of minutes. Okay, rock and roll.
Okay, thank you. So again, that language is in the statute.
Matt, was that the same observation you had?
It was.
Okay, all right.
Sorry.
Thank you. Lisa, I apologize for
No
the
problem.
interruption. Back to the condition or use of personal property.
Right. So the tangible property is that definition is in the statute. That's correct. And I believe your next question was whether or not by placing it, it becomes a fixture and maybe removes it from, I'm sorry, I forgot the last part now.
Whether or not it makes it real estate and takes it out of that waiver provision entirely because it becomes a fixture.
No, it's still tangible personal property. But the distinction is, and this might be where I cut out a little bit, is that it's not that green ball signal is not being used in such a way as to waive the state's immunity. In order for the state to have its immunity waived by the condition or use of tangible property, it must be put into action. There's several cases that talk about this, including the Cowan case, in which a patient at a state mental hospital was provided a walker and some suspenders. And those two things in and of themselves are not a problem, but they were then used to cause harm to the patient by himself. But the hospital was not held liable because there was no hospital employee putting those tangible pieces of property to use at the time. And so we're likening the green signal ball to that. It's the same type of thing.
Isn't this a little different than the belt and suspenders or the walker and suspenders? They were being they had been issued to the patient and the patient used them ultimately to commit suicide, they weren't being used for the purposes for which they had been issued, whereas the green traffic signal was being used for precisely the purposes for which the state had installed it.
It was merely functioning as it was intended to do, but it wasn't being used by an employee. And that's what the case law has held, is that it has to be put into use by an employee. And another case that demonstrates that, and I was mentioning it and it may have cut out during that time, was the Sampson case, the Sampson versus
No,
University.
we caught all but just a little bit. So
Okay, great. So a similar situation in which the cord that was stretched across the sidewalk was actually being employed for the use in which it was intended, but there was no state employee making a use of it. It simply furnished a condition that could perhaps cause a condition. This light is no different. It simply furnishes a condition that could cause something to happen. And in this case, what happened was an accident, but it wasn't because there was a state employee putting that to use. So there is no condition or use of tangible personal property in this instance. So moving back to the premises defect that needs to be shown to waive the state's immunity, looking at the first element that we talked about, the unreasonable risk of harm. These conditions do not impose a reasonable risk of harm. There's no evidence that's been presented that this circular green ball signal and a sag in the road pose an unreasonable risk of harm. First of all, the condition was open and obvious. And there are many cases that have held when a condition is open and obvious, there is no unreasonable risk of harm. There's a case in which a shrub has been held not to be an unreasonable risk of harm because it's open and obvious. There's another case in which someone stumbled over a pile of rubble that was completely open and obvious. Again, the governmental entity didn't waive liability in those situations. Here, the change in the topography was easily perceptible by thousands, if not millions, of drivers that had passed through this intersection between January and then the September date of this crash. In fact, Txdot has records that show, yes.
I've got to ask, is there anything in the record that will show the view from the left turn signal where this particular driver that made the unyielding left turn was situated? Because while you say it's open and obvious, it's got to be open and obvious to the person that's engaged in the activity. And, you know, it's like the Invisible Man. It's open and obvious if you're watching the show, but in real life, if there's an invisible man, that's the nature of the obstruction. So I'm having a little trouble with the record on what is the support for this sag in the road being open and obvious to the relevant person.
Well, I don't believe there are any photographs that were taken on the date of the accident from that perspective, but there are plan sheets in there that show what the intersection design is. And as I mentioned, there are many, many drivers that have navigated this intersection successfully over the 8 months prior to this accident. And, you know, we all know that driving is an extremely dangerous activity. You take on some risk when you do that. And we have to be able to perceive these momentary losses in visibility. It happens all the time as you drive over rolling hills throughout the state, particularly in the hill country. I think we've all probably done that. And we have to, especially going into intersections, exercise reasonable caution and care and keep a proper lookout. And the DeWin case speaks to that fact. We can't insure against what every driver will do, but drivers have the level of responsibility to make sure they approach these types of things with caution. Turning to the next element, Txdot adequately warned of this condition. We only had to warn or make safe, not both. And in this case, in addition to the panels of lights, which involved 5 signals at one light panel at each side of the intersection, Txdot also placed left turn yield on green signs, which would have again helped make up for any loss in visibility. So that's one thing that Txdot did to warn of the condition. Moreover, Txdot also designed these plans in such a way that they would have these signs and these signals set up to warn. This intersection was designed according to that plan. And that plan, again, is entitled to discretion because Txdot gets discretion to place its signals based on its engineering judgment. The Txdot employees that went out to the scene the day after this accident confirmed that indeed the intersection was set up according to Txdot's plan, for which it's entitled to discretion and immunity.
Counsel, I'm going to jump ahead in the argument because this is going to be where we need to focus a little bit. Your argument is all about it's discretionary and under the Texas 11 manual, which basically grandfathers the 06 manual. The appellee's argument is that this was a federal project and that the 09 federal manual is what controls. And it uses the word shall in connection with the use of the yellow blinking arrow. Can you jump straight into that and discuss that issue?
Yes, Your Honor. Txdot was not required to follow the National Manual on Uniform Traffic Control Devices. Txdot has its own federally approved manual. The 2006 manual that we talked about, that you mentioned, that was grandfathered, that was in place at the time this intersection.
Let me stop you there. Why do you say that when 23 CFR 655 says that a federal project shall conform to the national manual?
Because also in the CFR, in that same section or in that same chapter, is the ability of the states to create their own manuals if they are blessed by the feds. In other words, in this case, Txdot's manual had to be approved for substantial conformance with the federal manual. So that national manual sets the standards. Txdot has to do at least that much. And then Txdot can apply its own regulations once that is blessed by the Federal Highway Administration. In this case, both the 2006 and the 2011 manuals were in fact approved by Federal Highway. The 2011 state manual was modeled after the manual adopted in 2009. The letter from Federal Highway approving that is attached as Appendix E to our opening brief. The 2011 manual, as was mentioned, allowed the grandfathering of the traffic control devices before the approval of that 2011 manual because of the national concept of allowing non-compliant devices to be replaced as part of a systematic upgrade. So Txdot's manual does exactly what the federal manual does. And if you look at it from this perspective too, if Txdot, who already had these devices on order and whose manual said that was okay to do that, and the federal government had approved that language, Txdot had those devices on order. If they were to have to go back and reorder and change that out, et cetera, and not phase them in systematically as they need upgrading, as is the national concept that has been adopted by Txdot, we're wasting taxpayer dollars, we're wasting time. And there's no reason to believe that this signal ball, this circular solid green ball that had been the de facto standard for many, many decades in Texas, was suddenly not going to be effective anymore. The flashing yellow arrow would be replaced in the future, but it didn't have to be done at that time. And that was approved.
What provision is it of the CFR that says that the Texas manual, once approved, you don't have to follow the shell language of 655.603?
Well, it's actually in 603, Your Honor, and in 601. 601 basically allows the national and state manuals for the uniformity of the traffic control devices. And then in 603, B1 states a state can have its own manual if it's in substantial conformance to the national manual. Moreover, the states have to adopt the changes within 2 years to their own manuals that have been made to the national manual. So here in 2009.
I get the fact that the states have to have manuals and they have to be approved. I'm asking, where is there language that overrides the mandatory shell language of 23 CFR 655?
Well, it's not mandatory. And the manual itself, the national manual states that it is not mandatory. It sets the national standards that are to be followed, but neither the state manual nor the national manual are substitutes for engineering judgment. And so neither of these manuals are mandatory in that regard if there is an engineering judgment that can be made. So it may not.
Where's the language that the national manual is subject to engineering discretion?
Well,
is it in the manual?
Yes.
And is the manual in the record? And that's the other thing I needed to ask you about the letter. You said it was attached as appendix to the opening brief. Is it in the record anywhere?
Yes.
Wow.
Yes, it is. And I'll have to get you the exact page citation to that. But yes, it's in the record as well. In fact, I might be able to tell you really quickly. If you give me 1 second, I will flip to our appendix and let you know. It is CR 598. That's the approval letter from the Federal Highway Administration.
In the language that Justice Johnson is concerned about as to why the shall doesn't mean shall, where is the language in the manual that you say modifies that?
That's also in the manual, but I will have to find you the exact record site for that.
Okay.
I don't have it at my fingertips. I apologize.
That's fine. We do briefing and things until the Friday after on cases that are newly raised, so that's fine.
Thank you. Okay.
Mitchell, did I understand you correctly? That even if it says shall and seems to indicate that it's mandatory, that even in that situation, it is subject to engineering judgment?
That's correct.
So even mandatory is not necessarily mandatory under that interpretation. That is always going to be subject to engineering judgment.
That's correct, because you figure there are different situations throughout the country where the engineers are going to have the best information on the ground, and they are entitled to use their engineering judgment to make sure that they make designs that are safe and efficient, and they don't waive their immunity for their engineering discretion. And
doesn't this shall apply to that the national manual shall apply? I realize there may be engineering judgments that are allowed for in the national manual, but I'm talking more about whether the national manual or the state manual applies. And that's really where that question ends. We can get into the discretionary engineering calls later on, but I just want to know what the state's position is. Do you think that the shall language means that the national manual applies, or is there something else out there that says it doesn't? That's really the question I have, and I may not have phrased it very well initially.
I'll try to answer it as best I can. The state manual applies. The reason for that is the Texas legislature gave Txdot, directed Txdot to create its own manual, granted it discretion in doing so, and the feds had to approve it. If the federal manual was going to be made to apply to the states, why would you even offer the states the opportunity to have their own manuals that employ their regulations? There'd really be no purpose. And Texas courts have looked at this several times, and they have held in these cases that the manuals do not create a mandatory duty. And for more than 25 years, Texas courts have been looking at that. And specifically in the Andrews case, not only did they say that the manuals don't create a mandatory duty, they also say that not following the national manual does not waive Txdot's sovereign immunity. That's the Txdot v. Andrews case from 2004. So the manuals are just a standard for design. They're not a substitution for engineering judgment. So despite the federal requirements and regs allowing state manuals and allowing them to implement state regulations, Ms. Galloway asked you to hold that federal regulations control over Texas regulations, and that's simply not what the Texas Supreme Court has held. So I hope
what is the case that you contend holds that the federal manual is not mandatory?
Txdot versus Andrews.
And that was a federal manual issue, not a Texas manual?
It involved discussion of both, but it expressly states that Txdot's failure to follow the national manual would not waive its sovereign immunity. So it goes directly to the question.
And that was, in that case, the fact pattern involved federal funds for that project?
Let me look back at Andrews quickly. I'm sorry. I'm trying to get y'all a citation to that too. One sec. Well, now I'm just losing all my stuff. Let me see. Sorry, I'm looking for my note on that. And even if it did involve federal funding, that's the other thing that's at issue here. Txdot's agreement, or Txdot's agreement to have its own manual and to do what it has done in no way has waived its immunity. If anything, if Txdot in some way failed to comply, they'd be at risk of losing federal funds. We talk about that in our brief, but they don't waive their sovereign immunity. So again, this goes back to all of Txdot's decisions that are made pursuant to this manual being discretionary and still protected by sovereign immunity. And I see my time is almost up, so if there aren't more questions on this, I'm going to get you an answer to Andrews when I've got my rebuttal time, and that way I won't waste any time sifting through right now.
You're muted, Chief.
Any other questions for Councilman Mitchell at this time?
No, sir.
Okay,
No, sir.
you will have a 5-minute rebuttal, and at this time, the court recognizes John Carr, and counsel, you may, let me reset the timer, and I am going to start it this time on you. You may proceed when ready.
Thank you, Judge. May it please the court. The first thing we need to understand is what is the question for today. And the question for today is whether or not the plaintiff's pleadings affirmatively demonstrated that the court's jurisdiction to hear this case. And that's the Miranda case that, Texas Parks and Wildlife Miranda. And in that case, it says that you have to accept the allegations in the plaintiff's pleadings as true and construe them in plaintiff's favor. You also can consider in addition to the pleadings, the evidence that is pertinent to the jurisdictional inquiry, but you don't get involved in the merits of the case. The Txdot's plea to the jurisdiction can attack those pleadings in one or two ways. They either attack them on the face of the pleadings, or Txdot had the opportunity to include jurisdictional evidence placing the issue, the jurisdictional issue as a fact. And in this case, Txdot did not produce any jurisdictional evidence in a couple of significant ways. First of all, there is no evidence in the record that the 5-signal head that was installed was on order or under contract. Now, I say that with this. Certainly the plans that had been approved had the description of the light fixtures that were installed. But there's nothing in the record that says those lights were on contract or on order once the Texas 2011 manual came into being. The second area where there's no evidence that there's approval by the Federal Highway Administration of the cover letter of the executive director saying that you can use these lights that are, if they're on contract or under order. And I want to express that there's nothing in the record that shows the Federal Highway Administration approved that specific letter. They approved the 2000 manual, but that letter is not a part of the manual. It is an addition, a certification by the executive director only. And the executive director in his position does not have the authority to modify, do away with, or change any mandatory provision of either the Texas manual or the national manual. going further with what the issue is, we have sufficiently pleaded facts demonstrating jurisdiction to hear this case. And what Txdot's burden is, and once they have not done that, is to demonstrate an incurable defect on the face of plaintiff's pleadings. All of those come out of the Miranda case, and that was followed in the city of El Paso versus Majares, M-I-J-A-R-E-S, and that's at 2020 Texas Appeals Lexus 5160 out of El Paso. So the state's argument is essentially, this is all a discretionary function. But the state misreads both the manual and the plaintiff's pleadings. We do not argue and are not asserting that the selection of a traffic control device is subject to engineering judgment and is covered by the immunity. However, once a device type is chosen, you must follow the manual. What I'm saying is this: Txdot had the engineering discretion to choose whatever type of traffic control device. And remember, that's signs, lights, paintings, your stop sign, yield sign, blinking red, blinking yellow. All of those are traffic control devices that they can choose. So they had the luxury and the engineering discretion to decide they wanted to put stop signs at this intersection. But once they made and exercised that discretion is to choose the type of device to be employed, they do not have discretion then within that type to select among the various styles of lights. In other words, once they decided this dedicated left turn lane with a permissive protected left turn device, they had to follow the manual and have a forehead system. Now, why is that so? The Txdot has asserted that the 2006 manual was grandfathered into the 2011, and that is pure nonsense. The only reference that they have that they're relying upon is that cover letter, and that cover letter does not give them the authority to modify a mandatory provision. So the 2006 manual is completely out of the way. The CFR that was recited, and I've got it here, I'll get it to you in a second. The CFR says that a state can either have its own manual or it can follow the national manual. But in either case, it has to have substantial compliance with the national manual. But it also has only a 2-year period to be in conformity with that national manual. So in Texas' situation, once the national manual was approved in 2009, they had until 2011 to come up with their own manual that it substantially complied. They did. But in that manual, the 2011 Texas manual, it also provides, and this is, I believe, in the record, that for new construction, you had to use, for similar intersections such as this, you had to use the 4-light head system if you're going to choose and exercise your discretion to use lights as opposed to other forms. Okay, so the 2006 manual has absolutely no application. It is our position that the 2011 manual likewise has no application because this is a federal highway project for federal funds that mandatorily requires following the national manual. But even if the 11 manual applies, it says exactly what the 2009 manual says about a dedicated left turn lane for permissive protected left turns. You must not use the solid green ball. Okay, so Txdot does not have discretion once it exercises discretion to then say, well, I also have discretion to choose among the various styles what style I want to use. If you take that argument to its logical conclusion, let's say that for this intersection, they decided, well, we'll just use stop signs. You know, but I really don't like red. I think I want the stop sign to be green and not octagonal. I want it to be a parallelogram. They don't have the authority to do that. They can't change the style of a device once they make the selection. They must follow the mandatory provision. And why? Because the federal government, the federal authority, has a substantial and compelling interest that the users of the highways in the United States and Texas have a uniform system of traffic control, that they understand what all is all about. So, okay, I've kind of left on my notes, but one of the arguments that they raised also was that the national manual is not law. It is well established that a federal regulation, and this is under Chrysler Corporation versus Brown, which is in my brief, that the doctrine is so well established that agency regulations implementing federal statutes have been held to preempt state law under the supremacy clause. So the national manual applies because of preemption, but even if it doesn't, the 2011 manual says exactly what the national manual says. Okay.
Counsel, I know you're on a roll, but I need to interrupt you with the
Yes, sir.
question on the issue of in the 2011 manual. She has cited a introductory provision, and she says there's a similar provision in the federal manual, that it is everything is still about engineering judgment. So could you address that argument?
Yes, sir. Justice Gray, it is not questioned that the Txdot has the engineering discretion to analyze an intersection and decide what style or type of device is to be used. They did that in this intersection. They could have used a flyover and avoided any kind of traffic control device itself, but that would have been expensive. So they elected in their discretion to create an intersection that had dedicated left turn lanes, and in the specific left turn lane that this one was to be was permissive protected left turns. That's totally within their discretion. But once they decided to use lights, then engineering discretion goes away, and the mandatory language of the manual then applies. If you're going to use lights in a left turn, dedicated left turn lane where you're going to allow permitted and permissive left turns, you must use the four-head system. Now that's in both the Texas 11 and in the 2009 manual. So engineering discretion ends once a decision is made. Once the decision is made as to what kind of device is to be used, the manual controls to say what is to be used. And these manuals both say no solid green ball. And now why is that? There was a study conducted, and it's in the paper, and it's in the evidence too, that says that a solid green ball on a permissive left turn gives confusing signals to the left turn driver. And that's exactly what happened in this case with Miss Bernardo. She even told the police, and this is in the record, well, I had a green light. And he said, was it an arrow or a ball? It was a ball. That was confusing because she couldn't see the approaching traffic, so she makes the turn. The idea of a protected permissive left turn with a green ball was decided that was not necessarily the best and safest way. So therefore, the dedicated green arrow left turn, and in absence of that, the flashing yellow. That's where discretion ends. Discretion is, I want to use this type of device. Then the manual takes over and says, then that device has to conform with this for national unity.
What about the argument that, okay, they violated the manual, the remedy is not tort liability, it is loss of federal funding?
Actually, Judge, I think that is also nonsense. And in that argument, she recites the, let me get to it, the CFR as saying that that once, in order to get federal funds, all you have to do is have a state manual. That was 23 CFR 655.603 B3. That states and other federal agencies shall adopt changes issued by the Federal Highway Administration to the national manual within 2 years of the effective date of the final rule. It doesn't say anything about funding. It doesn't say anything about the necessity of a state, because states can choose to have their own manual or not have their own manual. But it is not the loss of federal funding. It is the uniformity of safety on the highway that is the predicate. And under that consideration, remember too, it has been held that a failure to apply a mandatory provision is not a discretionary function. So consequently, you know, well, I just got to say it. It's just incorrect argument to say that the only remedy is the loss of federal funds. The remedy has nothing to do with the injured parties if that's the case. So what we have here is a situation where they did not follow the mandatory provisions. Case law says that if you're not going to follow or apply the mandatory provisions, that's not a discretionary function. That is waived under the Civil Practice and Remedies Code.
So is it your theory? I just want to make sure I'm following you right, that that either the state or the federal manuals gave them no discretion once they decided to use a particular kind of traffic control device, the lights, that was not discretionary at that point in time. And so then under state law, if you don't follow mandatory requirements, that the state can waive their immunity. Is that where we're going with this? It's not the federal government requiring a waiver of immunity. Correct. It's state law.
Correct. I rely upon the Civil Practice and Remedies Code to say that in this situation, failure to follow a mandatory provision is not a discretionary function. So therefore, the Civil Practice and Remedies Code applies. Is that okay?
No, that's good. I just wanted to make sure I was clear.
Yes. Well, let's take a look at the argument about the personal property, premises liability, and special defects. She's arguing that this was not personal property put to use. If I may say so, I think that's a ridiculous argument, because that would essentially be saying, unless a Txdot employee is at that intersection, that the light system, which is personal property, as she admitted, is not in use to control traffic. You know, the turning on the power to those lights put that into use. Remember, use means to put or bring into action. That's the San Antonio State Hospital case that I cited in the brief. So turning on the power to that put that device to use. And so it was in use and in action at the time. An employee does not have to be present, or otherwise you'd never see any case against Txdot involving a traffic control device. Operation also refers to or doing a practical work. That's the Hampshire Fanet ISD case that I cited in the brief. So it is sufficient for a plaintiff to allege that the personal property, of the use of that personal property, contributed to an injury to be able to state a claim for a condition of property. And that is Fort Worth versus Gay, which I've cited in my brief. So as to the personal property side, we have sufficiently pleaded facts to establish that the court has jurisdiction to hear the case. Now, as to premises liability. As to premises liability, there's two ways to assert it. One of them is that the Txdot acted in a willful, wanton, and gross negligent way with respect to this premises. We have alleged that, and there's facts that we've asserted and put in the record that show that. But let's say that the jury goes to trial and the jury says, no, we're not going to say that was gross negligent or willful or wanton. Then it's up to the plaintiff to establish five factors. One of them is the condition created an unreasonable risk of harm. Unreasonable risk of harm is defined as when there is sufficient probability of a harmful event occurring that a reasonably prudent person would have foreseen, or some similar event is likely to happen. The foreseeability only refers to the general danger that is foreseeable. The second element is Txdot knew of the condition. In a premises liability, they have to have knowledge of it. This is not a should have known. In the third element is that the licensee does not know about the condition. The fourth element is Txdot failed to use ordinary care to protect the licensee. And the fifth element is Txdot's failure approximately caused the injury. So let's look at that. The improper signal causes confusion to the permissive left turn driver. That is creating an unreasonable risk of harm. Specifically with Miss Bernardo, who admitted that she was confused. In the constructing of the road leading up to the intersection, it contained a limited sight visibility in close proximity to the intersection and the lights, such that at given highway speed, Txdot knew of the risk of harm because of the limited sight distance being so close to the light that it knew that it had created a situation that was potentially harmful and unreasonably dangerous. And let me say this. This is not a design argument at all, because that's in the discretion. Txdot has every right to design a highway that includes an unreasonable risk of harm. But if they do, they have to warn of that harm. And that did not happen here. As to the Galloways, they didn't know of this situation. Good Lord, we can't talk to them because they're both dead. But they were at highway speed coming up and crashed. And then the use of the mandatory signal device and sign constitutes a failure of use of ordinary care by Txdot as it relates to left turn drivers. And the failure to warn the approaching drivers is a failure there that they did, but they also failed to warn the left turn drivers with the correct sign there, which brings up another point. Everything that the state has argued was from the perspective of the left turn driver. There's another driver coming up, and that's the user of Business 190. When they go through that sag and they can't see, and the left turn can't see them, Txdot had a duty to warn that driver also, but they did not do so. And everything that she's argued today has been from the left turn driver's perspective, ignoring the warning that should have been given to the approaching traffic. We have raised sufficient facts to demonstrate a material issue as respect to proximate cause. Now, with respect to special defects, we've pleaded two. One of them is that the improper traffic light created an unreasonable risk of harm that was known or should have been known by Txdot due to, first of all, the manual being modified to require it. Secondly, the report and investigation saying that this type of green ball light on the positive left turn creates a confusing situation. So they knew that. The sag in close proximity to the intersection gives the approaching driver less than 3 seconds once they come into a view to analyze and appreciate the danger. That required a warning, and it did not do it. So that was a special defect. And the use of the left turn light, as I'd said, in combination with the contour of the road was a special defect known to Txdot because they created it. In Denton County versus Binion, which is in my brief, it says that if it's an unreasonable risk to an ordinary user of a course of travel, then that is a special defect. Txdot had a duty to warn, and they didn't. In the city of Denton versus paper case, which I cited in the brief, the Supreme Court gave 4 helpful characteristics of what might constitute a special defect: the size of the condition, the unexpectedly and physically impairs an ordinary user's ability to travel on the roads, whether it presents some unusual quality apart from the ordinary course of events, and presents an unexpected and unusual danger. We have alleged facts, they're in the evidence, that show that these factors are an issue. They don't all have to be an issue, but at least one of them does, and we've alleged that there are sufficient. I've defined unreasonable risk. I need to define the warning. A warning must be adequate under the circumstances and warn the particular condition that puts the users at risk. That is Txdot versus Canales, and that's not in my brief. That is 2020 Texas Appeals Lexus 76, and that's a San Antonio case, and it was a petition denied. So is the obstruction to view a special defect? In the case of Txdot versus City of Midland, which is in my brief, the government has had actual knowledge that these stop signs were obstructed from view, and they had knowledge of the history of collisions at that intersection. So the Supreme Court held that obstruction to view was a special defect. Let's look at this one. In this case,
we've got the facts in this one. I think we're understand. Unless the judges have a question or want you to finish that thought, I need you to wrap it up.
May I close in one quick matter?
Let me see if they've got questions first.
Yeah.
Okay, yes, you may close.
The day this intersection opened, there was a left turn accident exactly like the one involved in this case on the day it opened. After that, there were 12 more before the Galloways suffered their deaths. 13 accidents give adequate notice to Txdot. There's a problem here, and you haven't done it right. Thank you.
Okay, thank you, counsel. Counsel, you may proceed when ready.
Thank you. So to turn quickly back to the question that was asked previously of where does the national manual say it's not mandatory? It's located at the clerk's record, page 541, and it's section 1A.09 of the national manual. Now, there was a lot that was put out there, and I didn't address a lot of the state law involved here, so I'd like to try to turn back to that quickly to respond if I could. First of all, the no actual knowledge piece of this, Txdot did not have actual knowledge. The previous crashes here don't give actual knowledge because actual knowledge requires contemporaneous knowledge of a dangerous condition at the time an accident occurs. There's a lot of case law that talks about this. Is
the knowledge going to be a fact question that he has to prove to a fact finder as opposed to a jurisdictional question that, I mean, because he's clearly alleged actual knowledge. So where are we on this continuum between what has to be pled, jurisdictional facts? I mean, have you conclusively proven that Txdot did not have knowledge? I guess it would be the way to frame it.
Yes, Your Honor, we have conclusively proven that. These accident reports don't convey actual knowledge for the reasons I just stated. Frankly, of the 14 accident reports out of the possibly millions of people that went through this intersection, while they're unfortunate and the accidents are not something anybody wants, only 3 of them had vehicles in the same position at the intersection, which, by the way, the intersection at all 4 sides did indeed warn all drivers of what's going on, not just the left turn driver coming from the south, Ms. Bernardo. Additionally, Txdot testimony in the record.
What do you mean they had warnings? What was the warning?
The signal lights combined with the signal, the sign that says left turn yield.
But there wasn't a sign that said limited sight distance or anything like that?
No.
Okay.
No, there was not, because the other was sufficient for warning. Again, let me move on, I guess, from the actual knowledge. Txdot didn't have actual knowledge. Bottom line, no premises defect here. They have to show all 4 elements of a premises defect, and they cannot. And in fact, 3 of the elements are negated by the record. We warned of the knowledge, we warned of the intersection, just as I mentioned. This idea that just because someone was confused about what the light might have meant doesn't create an unreasonably dangerous condition. There's no law that says that. There's no citation to support that. The only thing offered was their experts' judgment of an NCHRP 493 report, which concluded that a yellow flashing light or flashing arrow might be better than the green circular ball that had been the standard for years. That doesn't create an unreasonably dangerous condition. Back to the grandfathering of the manual, or grandfathering of the devices and the letter at the beginning of the manual, that is included in the Federal Highway approved manual. And in any case, it's a discretionary act of Txdot to be able to say, this is how we're employing our manual. And the manual, again, allowing these phasing in of devices as they become necessary to change, comports completely with the national manual. Again, drivers on all sides had the same warning. There were a couple of cases cited just now that were not cited in the brief, Txdot v. Canales, and the 2020, there was a Texas Appeals Lexus case I did not catch the site of, so I'm sorry, I cannot address those. I was not provided those prior to argument today. With respect to the sag in the roadway being a special defect, that's absolutely not the case. The only way a court can find a special defect is if it is like an excavation or obstruction. It's not enough that it's unexpected or unusual, and the Texas Supreme Court has held this again and again. And the Bainon case that Mr. Kerr referred to said specifically a court cannot classify as a special defect something that is not like an excavation or obstruction. The case law is very clear on that. And Ms. Galloway's own expert admitted that the sag is not an inconsistent feature of the roadway at the record at page 147. Ms. Galloway also conceded she's not challenging the contour of the road because that's a matter of Txdot's discretion, and that Txdot had the right and discretion to design the highway as it saw fit. That's in the reporter's record at pages 13 and 21. So the part of the road itself was nothing like an excavation or obstruction. An excavation or obstruction is a hole that covers 90% of the travel surface, like in Eaton, or a large traffic sign that's become dislodged and lands in the middle of the roadway, like State v. Williams. Undulations of topography don't impede traffic in the same way that those types of things would. And finally, the idea that this green circular ball proximately caused the accident is simply not sustainable. There was no proximate cause there. There's nothing showing that a flashing yellow would have prevented this accident. It's not, but for this green ball, this accident wouldn't have happened. And on top of that, it's not foreseeable. Again, many cars passed through this intersection without incident, and the green ball was the de facto standard for years, and it worked just fine. There's no reason to think that this couldn't still be a safe maneuver. And even their expert admitted that but for the failure of Ms. Varnado to yield the right-of-way to the Galloways, this accident wouldn't have occurred. That's in the clerk's record at pages 445 to 446. There's no evidence that but for the installation of the circular green ball that the accident wouldn't have happened. So again, the state's position is the state manual is what controls here. Txdot followed that. Everything that it did with respect to that was entitled to discretion. All of that's been blessed by the federal government. And right now you're being asked to tell the state of Texas that its own regulations are trumped by the federal regulations, when that is not what the CFR envisioned. The CFR, by the way, again, the idea that a regulation preempts state federal law, that may be the case. These manuals are not regulations. They state as such, particularly at section 1A.09 at the record at page 541. They're design standards. They're not substitutes for engineering judgment. So just to close quickly, Txdot's use of a circular green ball at that intersection was discretionary. It was an action for which Txdot's immunity should remain intact. Thank you. I see my time is well up.
It's all right. Any questions in the closing from the judges?
No, sir.
Okay. This case is submitted. It actually, I think, had already been submitted, and then we chose to do the oral argument on it. And so we thank y'all for appearing today. Excellent arguments all around. I think you've helped us frame the issues, and we will issue, briefing. I have to say two things, and this is what caused me to think about it. Rex was always, former Justice Davis was always very good at reminding me of the need to supplement with briefing or citations of cases that were not previously provided. So Counselor Carr, you will need to supplement and it can be a letter, and so that we have that citation and opposing counsel will be able then to address it. Recognizing that Rex is not with us today reminded me that you all are the participants in Justice Matt Johnson's first oral argument. And so we're pleased to have him on board today. And this is his first oral argument appearance with the court. Unfortunately, in normal times, we would convene afterwards and take photographs of the new constitution, of the new makeup of the court. Unfortunately, due to C-19, we will be unable to do that in these circumstances. In fact, we usually do a court-wide photo on this day. And so, Matt, I apologize to you for not being able to do that. As soon as we get opened up and are able to have an all-court participation on the day that we have oral argument, we will take those court photos. And besides, it would be the only court photo that sported not one, but two judges with facial hair. So you have the floor if you want it, Matt.
Oh, no, thank you for the kind remarks. And I sure appreciate the good arguments from counsel on each side today. So bear with me, I'm new at this, but I enjoyed the arguments.
Thank you, counsel. This case is adjourned and we will proceed for those that are with the court to post submission